settlement on paid 10,000 to sureties once in 4 months before so and so forth.
Obliged, my lord.
Serial number 8, Criminal of LTD 1549 of 17, Mr. Ramesh.
So the bail of this petitioner was
Yes?
yes. In this case, Your Lordship, the appellant was convicted for the offence under Section 304B, sentenced to arrive for 10 years, Your Lordship, and he remained in custody for about 8 years, 4 months.
How?
Initially, the case was lost. For the offence under Section 304B.
Yes.
He has been tried, Your Lordship. Charge has been framed as per page 20 of the internal page, 304B and 302 of the IPC also. It has been alleged that from 2-3 kilometers away from the house of this petitioner, his wife was found dead. That is by
Custody.
gunshot.
Custody, more than 7 years, 7.5 years.
8 years, Your Lordship, more than 8 years. 13 he is in custody.
Give me the date. Give us the date.
Yes, he's in custody since
Where have you stated?
27/12/27/30, madam.
Where have you stated?
27/12/2013, para 5 of my petition, Your Lordship.
27/12/2013.
7 years, 6 months, Your Lordship, on that day. That is 2021.
8 years. Because the appellant is the convict who has been sentenced to undergo RI for 10 years for committing an offence punishable under section so and so. Next, the appellant pays for grant of bail after suspending the sentence. So, the appellant is in custody for more than 8 years, and the sentence is only of 10 years. Considering the period of custody, the is once a month, once in 4 months before so.
Madam, in this, my name is mentioned, madam, in the place of
Yes.
Pankaj Kumar.
You send your slip, Mr. Satish Prasad or something. Serial number 9, Criminal of PTB 2095 of 17, Mr. Suraj Singh, Mr. Indrajit Sinha for the petitioner.
Appellant convicted under section 366 7 years and 20,000 fine, and under section 376 10 years at 1 lakh fine. Earlier, IA was dismissed and withdrawn. Lordship. Subsequently, Lordship, on the last occasion, ordered to move before this court after completion of half of the sentence. And that period has been passed. Lordship. He is in custody since earlier 5/8 to 25/60 for 9 months 12 days, and now from 6/11/70 to 6/4/22 4 years 5 months, total 5 years 2 months and 12 days. Lordship, in this case Lordship may have a look of FIR. Lordship, केवल FIR देख लीजिए लॉर्डशिप. इन लोगों ने 13 से कमिटेड रेप, 13 से रिलेशनशिप में रहा और 15 में भाग के शादी कर लिया. शादी करने के बाद ये केस किया. शादी करने के 1 महीना के बाद मैरिज ऑफिसर भी एग्जामिन हो गया. लड़की मैरिज ऑफिसर बोला कि मेरे सामने शादी किया. बीच में एबॉर्शन भी हुआ 2 बार. victim was examined at PW2, sorry PW1. भाई का केवल स्टेटमेंट देखने भाई और फादर का who are PW2 और PW5 लड़की. PW2 का सेकेंड पेज पे देखा जाए लड़की. PW2 का पेज 3 लड़की. सुलोचना कुमारी विक्टिम मुझसे एवं परिवार की किसी सदस्य को बिना अनुमति के अपने मन से प्यार करती थी. उसके बाद पेज 4 में लौटती. 24/7/15 को सुलोचना कुमारी घर आई और बोली मैं अशफाक से शादी कर ली हूँ. मुझे और परिवार के सदस्य को इस बात में सदमा लगा कि बहन हिंदू होकर मुस्लिम अशफाक से शादी क्यों की। इसके बाद 8 दिनों बाद अशफाक ने गांव में अपनी शादी का हल्ला किया, वीडियो बनाना शुरू किया। इससे हम लोगों को चिंता होने लगी। सब्सिक्वेंटली अशफाक ने मेरी बहन से शादी कर लिया था, इसलिए 24 तारीख को घर लौटने पर मेरी बहन ने जाकर केस किया। इस संदर्भ में गांव वाले को कोई दबाव नहीं था। मुझे जो भी जानकारी मेरी बहन अशफाक से बताई लोग, उसके फादर को क्या लौटे। मैंने कॉज ऑफ केस हु एग्जामिन्ड एज केवल उसके फादर का देखा जाता।
You are in custody since more than half this. You have completed half the sentence.
Yes, that's it. 5 months, 5 years, 2 months, and 12 days, not
5 years, 2 months.
12 days.
देखिए, heard the counsel for the appellant, heard the counsel for the state, the petitioner pays for so and so, so and so. The counsel for the appellant refers to the order dated 30/9/2021, passed by this bench, wherein liberty was granted to the appellant to renew his prayer after completing half the sentence. The counsel for the appellant submits that the appellant has remained in custody for 5 years, 2 months, and the sentence which has been awarded is of 10 years. 10 years. With a fine of rupees 1 lakh. Full stop. Now, what is the fine? 1 lakh for committing an offence under section 376, for committing an offence under section 366, and a fine of rupees 20,000. Uh, 1 lakh for 376, 20,000 for 366. Full stop. Considering the submission that the petitioner, the appellant has remained in custody for more than half the sentence, we are inclined to allow this IA. IA allowed, so the sentence be suspended. The appellant be released on bail 10,000 two sureties. So it is made clear that before accepting the bail bond, the court concerned will be satisfied that the appellant has uh, completed half the sentence. First, if it is found that the appellant has not completed half the sentence, the bail bond will not be accepted, and the fact should be immediately communicated to this court. First, further, during pendency of this appeal, the appellant will mark his attendance once in 4 months before registrar so and so court.
Serial number 10, Criminal Appeal DB 2248 of 17, Miss Suchitra Pandey for the petitioner.
Wait, please. My lords, in this matter, the appellant has been convicted under section 302 for life, my lords, wherein and the fine of rupees 5,000 has been imposed. She's in custody since, my lords, 18/10/2011, and that is mentioned in the order sheet judgment, my lords, at page 20, my lords. She's been throughout in custody. Now, my lords, the prosecution. More than 10 years, my lords.
More than 10 years.
Yes, my lord. Judgment, my lords, page 20.
Page 20.
20 of the judgment. She's the lady aged about 44 years and in judicial custody since inception of this case, that is from 18/10/2011. Thereafter, we moved for a suspension of sentence here, which was rejected, my lords, earlier in 2019. 18/10/2000. Now, my lords, the prosecution. My lords are there.
So repeatedly you have blowed upon the deceased.
My lords, now I'll come to the case, my lords, merits of the case. Now, my lords, the prosecution case in brief, as per the FIR, is that on the alleged date of incident, the informant heard the noise of one of the deceased, and thereafter he went there and tried to save them. He made halla, and thereafter but she was blowing. She kept on blowing repeatedly, using the weapon on the two deceased people, and thereafter she ran away from there shouting that she has killed those two people. Now, my lords, in my lords, the informant, who is also PW4, my lords, he has completely given a different statement in his examination in chief, my lords, and also in his cross examination, where he has completely denied that he was there at the place of occurrence or he saw anything happen there. So he is not at all an eyewitness. All that stands, my lords, throughout is that they heard that somebody was screaming that she has killed these two people, and they are saying that it is her who has killed. Now, there is nothing to substantiate it, my lords. There is no other evidence which would corroborate with it. Now, there is no recovery of the clothes which she was wearing there, or the clothes of the deceased, my lords, to match that the blood stains were there, or the alleged weapon which was used, my lords, that has not been recovered, my lords. That is the statement is only there that they heard she screamed that she has hit those two people and killed them. That's the only thing which is against her, my lords, all throughout. All the witnesses, my lords, the PW1, my lords, he has denied in para 4 that he saw her running with the blood-stained tangi, my lords. He has also not seen her. PW2, my lords, he is again a hearsay witness. PW3 also, my lords, he is in cross-examination para 3, he has stated that he is not an eyewitness to the statement, to the incident, my lords. Similarly, in fact, PW4, who happens to be the informant, he has completely gone back and he said that I have not seen the incident. I went there on the next day, my lords. Similarly, PW5 and 6 have turned hostile. PW7, my lords, he is again hearsay. PW8 is the doctor. PW9 is the IO.
Who is the APP? Who is the APP? Take a 100 concept of the appellant. None appears for the state. Full stop. The concept of the appellant raised for so and so. She submits that the appellant is in custody from 1810-2011, which is more than 10 years, and there's no likelihood of the settlement to be taken up in near future. She submits that the appellant, being a lady, be released on bail. Next paragraph. Considering the period of custody, which is more than 10 years, and there is no likelihood of the settlement to be taken up in near future, we are inclined to release this appellant on bail. After suspending the sentence, 10,000 judiciaries once in 4 months before scheduled for registration.
Lordship, if you
Right, my lord.
I am appearing, Your Lordship, for the state.
What do you have to say?
Yes, what is your submission?
What is your submission?
Non-appearance may be
Why
not be.
this proceeding is a live proceeding, then what will I write? But so and so who is not here. Will it be proper? Just away, madam?
No, Your Lordship, that is
Then,
not.
then why do you ask us to do something improper? You know that this is improper, then why do you ask us? Are you appearing? You are the APP, or there's some other APP?
No, Your Lordship, there is another AP, Your Lordship.
Then nothing will happen to you. Yes, next.
Serial
Next,
number
ma'am.
11, criminal appeal DB 590 of 18, Mr. Arvind Kumar Singh, Mr. Amrit Kumar Singh.
My lord, I am appearing for the appellant in this case, my lord.
Yes.
My lord, in this case, the conviction is under section 302 IPC, read with section 498A of the IPC, my lord. The case of the prosecution is, my lord, that the deceased victim was protesting for something, and the accused, my lord, now the convict, Pradeep Sahu, he became furious and he poured kerosene oil and light her with fire. Now, my lord, in the entire, I have read the judgment, my lord, the entire judgment, there is no recording that a smell of kerosene oil was found on the body of the deceased, my lord. And it's a case of 302, so the intention to kill should have been there. That has also not come in the judgment. Now, my lord, will kindly find he is, after the conviction, he is in jail since the date of conviction in 2018. So, March 2018. So, more than 4 years have elapsed in jail after the conviction. And before that, about 2 to 2.5 years, he was in jail custody, my lord.
Only 6.5 years.
He surrendered. He surrendered on 25th of February 2010, my lord. He himself surrendered.
No, this is not a case.
My lord, about 7 years he has remained in jail, my lord, approximately. And my lord, one thing, my lord, may kindly take into consideration, his son is about 12 years of age now. I have annexed as an annexure, my lord, to my present petition, IA petition, my lord. And the mother of the convict is more than 75 years of age. Son is will become guardianless if he is not, if the convict is not released on bail, my lord.
What sort of son you are? You are praying for your mother's death.
No, my lord, my son.
So,
My son
who is
is
75 years? Who is 75 years?
my mother is 75 years
You
old.
are saying your son will become guardianless. That means you and saying that your mother is 75 years and your son will become guardianless means you
No,
are praying for your mother's death.
no, my lord. I say she is not in a position to look after the son, my lord. I have annexed the photograph, my lord. Page 16, my lord.
Heard the counsel for the appellant, or the APP. The petition, the appellant praised for suspension of sentence on next trial. We have heard the counsel and gone through the record. We find that the case has been registered, the appellant is convicted under section 302 and 498 capital A of the Indian Penal Code, and this imprisonment is for life. The FIR is the dying declaration of the deceased. The
No,
deceased was
mother says कि मेरे सामने पुलिस कोई बयान ही नहीं लिया.
final hearing.
I realize, my lord. About 7 years he has been in jail, my lord.
Considering the nature of allegation, even if the appellant is in custody for nearly 7 years, we are not inclined to release the appellant on bail business.
My lord, hearing may be expedited if my lord pleases.
You pray. Liberty is reserved to the appellant to pray for early hearing of the appeal.
Obligement. Obligement.
Serial number 12, Criminal Appeal DB 800 of 80, Mr. Anjani Kumar for petitioner.
May I pray, Lordship? The appellant is convicted under section 376 IPC and 6 POCSO Act, Lordship. The maximum punishment is 14 years, and also, Lordship, RI for 7 years for the offence under section 366A of the IPC. Lordship, appellant is all along in judicial custody and completing more than 7 years, Lordship, 7 years, 1 month. Is the half of the custody served, Lordship.
I have sent the memo of evidence, my lord. A custody report, my lord.
And also, Lordship, as per the statement of the
Yes.
altogether, Lordship, 11 prosecution witness examined, including the victim, Lordship, is the PW4. And she also, Lordship, categorically stated that in para 6 लॉर्डशिप, ये केस हमने अपने दादाजी के कहने पर किया है। मैं सनातन नायक से शादी करना चाहती थी। यह केस मेरे दादा राम विकास महतो के कहने पर अभियुक्त के ऊपर की हूँ। मैंने थाना में केस नहीं की थी, थाना में केस प्रकाश ने किया था। पुलिस मुझसे पूछताछ नहीं किया था। इन पारा 8 लॉर्डशिप, मुझे कोर्ट में बयान देने के लिए पुलिस लेकर आई थी। जिस वक्त मेरा बयान हो रहा था उस वक्त पुलिस बाहर ही खड़ी थी। मजिस्ट्रेट साहब के पास मैंने जो बयान दिया था वह पुलिस ने मुझे बताया था। जो बयान मुझे पुलिस ने बोलने के लिए बोला था वही बयान मैं मजिस्ट्रेट साहब के सामने बोली थी। मैं सनातन नायक से शादी करना चाहती थी। सनातन नायक मेरे साथ गलत काम किया है। मुझे मालूम है कि लॉर्डशिप एंड ऑल्सो दैट land dispute between the parties, they are also admitted by the victim lordship, and also as per the medical report, not definite opinion about the rape lordship.
You are in custody
Since lordship 10th of February 2015.
continuously.
Yes, lordship, continuously. All along in judicial custody, lordship.
Heard the counsel for the appellant, heard the counsel for this. Who is for the state?
Yes, my lord, I am for the statement.
Heard the counsel for the state. The appellant prays for releasing him on bail after suspending the sentence, as he has been convicted under section so and so of the IPC and also. As per the counsel for the appellant submits that the appellant is in custody from 10 to 2015, whereas the sentence imposed is of 14 years. He refers to the statement of the victim girl, wherein, and as per victim girl, he submits that the victim girl has stated that she wants to marry this appellant, and there was land dispute. That's the next one. Considering the period of custody, which is 10 to 2015, which is not the sentence, we are inclined to, and also considering the statement of the victim girl, we are inclined to allow this IA after suspending the sentence. Also, the appellant will release on bail 10,000 to rupees. While accepting the bail bond, the creditor will be satisfied that the appellant has remained in custody, has served out the sentence. First of, if it is found that the appellant has not completed all the sentence, he will not be released, and the bail bond will not be accepted. That event, the court concerned will immediately inform this court. Further, once in 4 months before.
Oblige.
Serial number 13, criminal appeal DB 943 of 18.
May please Lordship.
Srinivas Roy.
May please Lordship, I am appearing on behalf of the appellant, my lord. In this case, not in terms of the previous order, because he was granted, my lord, the benefit, my lord, for 1 month on payroll. Therefore, my lord, he surrendered within time. For that reason, my lord, your lordship has been pleased to pass an order on 9/12/2021 asking me to file the supplementary affidavit with the fact that he surrendered. Now, in this, I have filed a supplementary affidavit on 24th of September 2021 which was followed by a recent, in March 2022, enclosing therewith, page 5, the letter of the jail superintendent, because he was granted the benefit of payroll for a period of 1 month during COVID-19, Milord. Your Lordship will kindly see page 5. This letter is dated 19th May 2021, stating that, may I be permitted to place it, Milord? Last supplementary affidavit, Milord.
No, you have surrendered.
Yes, I am surrendered and I am in still custody. Now, Milord, in this case, there 6 persons were tried together. Out of them, Milord, this appellant has been convicted under section 302 IPC. One Israfil was convicted under section 307. Punishment is 7 years. Petitioner is life imprisonment. And the other persons were convicted under section 323. Now, my Lord, your Lordship may kindly see in course of a meeting for holding an election in the village, there had been a dispute and quarrel between two parties. It is alleged, my Lord, specifically this petitioner is concerned, this appellant was armed with arrow and bow. But he alleged to have pierced he alleged to have shot bow which hit the chest of the deceased, but Israfil, your Lordship may kind, PW3 is the only eyewitness. And PW3 in his paragraph 1 categorically stated that this appellant तीर चलाया, जबकि तीर धनुष से तीर चलाया, इसराफिल ने फरसा देकर उस तीर को मारकर घुसा दिया. That is Israfil. Your Lordship, just see paragraph 1 of PW3, who is the eyewitness. This is the Israfil who pierced that arrow with the help of farsa on the chest. And according to para 16 of the trial court judgment PW2, the postmortem report, doctor has said lacerated wound on right side top, and then blood penetrating wound causing deep, that is chest injury. So, my Lord, the appellant is responsible for shooting the arrow, and Israfil is responsible to pierce it with the help of farsa. That is the PW3 only witness, only evidence on record. I remained in custody more than 7 years. More than 7 years. Israfil has been granted bail because it was single bench matter, not criminal appeal, because he was punished with a punishment of 7 years under section 307. And due to good conduct, he was granted payroll benefit. He again surrendered within time. And then for last 3 years during trial, and after conviction 4 years about. So about 7 years.
Payroll was probably due to COVID.
COVID COVID से अटैक नहीं हुआ था हुजूर, सबको छोड़ रहे थे जिसका गुड कॉन्डक्ट है. इनका गुड कॉन्डक्ट था तभी हम, that is of course, Milord, the payroll was granted for 1 month and he surrendered within time. And it a dispute, all on a sudden the dispute arose, fight between both the parties. Both were armed with each other.
Mr. Sahni, what is the procedure in a criminal trial?
Yes,
if one person is convicted for less than 10 years and another is more than 10 years, then who will hear?
The 7 years, Milord, of course, he preferred a single bench appeal before the honorable single bench.
What is the procedure? If out of a same judgment, there are 4 convicts, 2 convicted for 7 years and the rest convicted for further 2 convicted for more than 10 years.
Yes.
Who will hear this appeal?
The division bench will hear.
So,
because Milord, the judgment is the same. Now it is to be tested. The one judgment will be tested by the honorable single bench.
That cannot be.
That cannot be.
That cannot be.
Because division bench is in season of this matter. Naturally, this same judgment will be tested by both courts. There cannot be parity in the judgment.
Yes. So let me see single judge. Now the matter was placed before the single judge?
Because, Milord, it is 7 years conviction, therefore, Milord, most probably.
Maybe.
That is Criminal Appeal SJ number 1226 of 2018, 1226 of 2018.
Procedural irregularity committed.
Yes, not yes. It should have been before the Honorable Division Bench. Because same judgment can be tested by the same equal strength of the bench.
Yes.
And it is since it is a single bench matter, he is enjoying the privilege of bail, although, of course, not PW3 is specific statement made by him. There are two of the judgment will also shows what I submitted for Lordship with reference to the FIR also and PW3. There are two of the impugned judgment. There are 9 of the impugned judgment discussed in PW3. Kisun Mia is the deceased. Israfil Mia assaulted on the forehead of the Etwari with forehead bleeding started. Thoroughly also assaulted Kisun Mia with bow and arrow, which is struck at the chest of Kisun Mia. Israfil Mia pierced the bow and handle of Farsa, and Kisun Mia fell down and was wriggling.
Sentence is for
Life imprisonment so far this appellant is concerned. 302.
and you are in custody since?
I am about 7 years, not 3 years during trial. I have stated in my IE interlocutory application.
So when
That
you are
is,
not completed 7 years also.
no, 7 years approaching, not 2 months is due.
Not now.
7 years, more than 5 years. Not.
Yes. The counsel for the appellant raised for suspension of his sentence.
2 months is left to be completed.
And are praised to release him on bail. So he submits that the appellant is in custody for more than 6 years, and the other who convict has been granted bail by a single bench of this court. He submits that this appellant is the only convict who has been convicted for committing offence punishable under section 302 of the Indian Penal Code, and thus serving life imprisonment. He submits that though there is an allegation that the appellant has shot an arrow, but it is one
Israfil Mia.
Rafil Mia. who had pierced the arrow with the help of a parsa on the chest of the deceased, inside the chest of the deceased. Next one. After hearing the appellant, counsel for the appellant, we find that there is a direct allegation against the appellant of shooting an arrow, which caused death of the deceased. Though there was a dispute in a meeting, yet this fact has not. This fact has come to light. The opposite fact has come to light in evidence. Full stop. Considering the nature of allegation and the materials against this appellant, we are not inclined to release the appellant on bail. Full stop. The appellant, if so advised, may pray for early hearing of this appeal.
Or at this stage, as your lordship.
What is the next stage taken?
जब 7 साल पूरा हो जाएगा हुजूर तब.
That is not a stage.
Then
no stage of
early hearing part.
9 years, 11 years. Okay. Yes, next.
Bill number 14, Criminal Appeal DB 971 of 18, Mr. A.K. Sani for petitioner.
May please lordship. In this case, the conviction under section 376 2G, 302, 201, and 34 of the IPC. RI for 10 years under section 376, maximum punishment 302, life imprisonment, with fine of rupees 15,000 and 10,000 on each count. Now, the allegation, his prayer for bail was rejected on 6th of March 2019. Now, he is in custody throughout for a period about 3 years, for a period about more than 8 years. Number, your lordship will find the allegation is that Santoshi, the sister of the informant, left home at 4 p.m. to attend the call of nature and did not return. Then on 22/10/2011 at 6:30 a.m., dead body was found in a bush. Number, the family members were examined, although 19 witnesses were examined. Out of them, 1, 2, 3, 5, 12, and 14. They are the family members of Santoshi, the deceased, and the PW17 is the doctor, and 18 and 19 the FSL experts, apart from the PW16. 5 persons were declared hostile. So far, the conviction is based upon, if you may kindly see para 32, the circumstances. It is based upon a circumstantial evidence. Para 32 summarized the circumstances and how the conviction has been recorded. Para 32. Lordship may kindly see page running page 34, inner page 17 of the impugned judgment. IO of the case, PW16 stated in his examination that he had taken Fardban of Sunil Paramani, and thereafter, on the basis thereof, on 21/10/2011, she was out of the house, and somebody has murdered her, pressing her throat after raping her, and had left the dead body. That was the allegation. Till then, nobody could be detected. Nobody could be identified. Thereafter, my lordship will kindly see in the body and number of 7 evidence of his paragraph 7, he stated that inspected the place of occurrence, and thereafter it was in the lonely place. Dupatta and all these things were detected. Exhibit 5. Then it is said, my lord, that witnesses, namely Anjali Paramanik, Chandana Paramanik, Rohit, and Satyanath Paramanik, and all of them had told that all the 4 accused persons have murdered and the deceased after raping her. That is the basis of the suspicion arose. And on the basis of that suspicion, next page your lordship will find, they started that they have full suspicion that all the 4 accused persons have murdered the deceased after doing bad thing with her. And then, my lord, the Birbal Mahato stated before him that Bablu Kaur, working in the hotel of Sudhir Mahato, had told that all the 4 accused persons had assembled at the hotel in the evening, and they had expressed their suspicion that all the 4 persons. So entire thing is based upon such circumstances and surrounding circumstances having suspicion.
Your sample was also taken.
Yes, this is first part. Second part, then sample then my lord, FSL report, then connected with the offense.
So your sample matches.
No, my lord, that is of course the sample. The sample was of course taken, but it does not show that SFL, the SFSL, that is what the witness has further stated that party containing such and such swab, and that could be matched with the petitioner's sample, my lord. Purely on suspicion, my lord, he has been convicted.
Scientific
Besides the confessional statement, Exhibit 10.
Scientific investigation was carried out. Let us see.
DNA profiling of the accused, namely Ramesh Singh, matched with the DNA generated from the blood samples of Ramesh Singh. That your lordship will get page 38, paragraph 34. Paragraph 34. The last sentence note at page 38. Similar is the Miller position in page 39 also. The FSL report shows matching of DNA profiling of the accused Ramesh Singh into the matter. This way, the chain of circumstantial evidence against the accused persons are complete. It is against Ramesh Singh. The petitioner is Angad Paramani.
Just a minute. Cases of the year?
Cases of the year, Miller, 2011. Date of occurrence is 22nd October 2011. 21st October 2011. FIR is 22nd October.
FIR is?
22nd October 2011.
Just a minute. Just a minute.
Yes.
In this case, we are very on the informant.
Mr. Sawani, I will not hear this. 2011-12, the name familiar.
Maybe I do not know.
Let this case go out of. Let this case be listed before an appropriate bench in which Anand Sen J is not a member. Comma with the leave of the Honorable Chief Justice.
Obliged.
Serial number 15, criminal of LTB 1044 of 18. Mr. Praveen Kumar.
May I pay your lordship? This case, lordship, the sole appellant is before your lordship. On the last occasion, lordship, on 28 February 2019, lordship, the first attempt of bail, lordship, was dismissed as not pressed after some arguments. Thereafter, lordship, it is coming for the first time. Now, in this case, lordship, the appellant before your lordship has been convicted.
Second attempt. This is your second attempt.
Second attempt, lordship. After it was rejected on 28/2/2019, lordship, as not pressed after some arguments, lordship.
Yes.
Lordship. This Lordship, the appellant has been convicted under Section 302 of the IPC for life, Lordship. Now, Lordship, the circumstance which are against this appellant is that, Lordship, the FIR was lodged, Lordship, by the wife of the deceased, who died, Lordship, and his dead body was found in the forest before lodging of the FIR, Lordship. The case of the prosecution is that, Lordship, that there was some satsang in the house of the deceased, and thereafter in the night, Lordship, he was going to accompany some ladies to their house. Thereafter, he did not return in the night. When in the morning, Lordship, the dead body was, the wife tried to find out the husband. She went to the house of one of the person to whom he had gone to live in her house, Lordship. Thereafter, he came to know that near the house of one Sarkar Kerai, he is PW9, Lordship. The appellant has, the deceased has left, and thereafter he had gone from that place. Then, Lordship, with all the villagers and other persons, Lordship, he tried to search the husband, but the dead body was recovered, Lordship, thereafter. Now, the only circumstance, Lordship, the only suspicion which has been raised in the FIR itself, that there was some previous enmity and the case was lodged by the husband of the informant against this appellant, Lordship, and as such, he has threatened that he will मैं देख लूंगा for dire consequences, and as such, Lordship, the suspicion was raised. Now, Lordship, the next circumstance which has come against this appellant is that he was, after he being arrested, he has given his confessional statement, and on his confessional statement, Lordship, one mobile cover without the inner parts, mobile cover, front cover and the back cover, along with a battery, was recovered near one Sukha Nala. That is the allegation that has which has come against this appellant, and on that basis, Lordship, the
who is the owner of that mobile?
Lordship, the TIP was done. It is said that the cover of the mobile, Nokia mobile, Lordship, an old Nokia mobile, that was recognized by the informant, Lordship, who was the wife of the this appellant, Lordship, the deceased. Now, Lordship, what I am submitting before this court is that even the IO who has been examined as PW16 has said, Lordship, nothing about the recovery of the weapon. That was a sharp cutting weapon which was used in commission of the offense. And it is very much surprising that when a mobile, a piece of the...
Yes, continue.
Lordship, I'm sorry, Lordship. A piece of the mobile, some pieces of the mobile was recovered, but not the actual weapon was recovered by the confession. Neither any statement is there in the confession. Now, Lordship, the two persons are there in the as a witness, scissor list witness of Exhibit 5. That is PW9, Lordship, one Sarkar Kerai, and PW15 Shashi.
Only on the basis of the seizure you have been made
yes, Lordship. Again, except that nothing is there, Lordship, and both the scissor list witness have been declared hostile.
For the counsel for the appellant, who is for the state?
Lordship, I appear on behalf of this.
The petitioner please for after hearing the counsel for the appellant, we find, and after going through the record, we find that admittedly there are no eyewitness to the occurrence of murder. This appellant has been made an accused, thereafter convicted only on the basis of a recovery of mobile covered and the battery, which later on was identified to be of the deceased. Considering the aforesaid material, we are inclined to release the appellant on bail, 10,000 to share release after suspending of sentence immediately. The appellant will mark his attendance once in 4 months before service.
Obliged.
Yes, next.
Serial number 16, criminal appeal DB 1091 of 18, Mr. Soumitra Baroi.
Your Lordship, I am appearing on behalf of the appellant. Your Lordship, the appellant has been convicted under sections 366A, 34 and 376 of the IPC and section 4 of the POCSO Act. Your Lordship, the appellant has been sentenced to 10 years under the POCSO Act and to 7 years under the Indian Penal Code. Your Lordship, as per the FIR, the informant was dragged from a field where she had gone to throw the cow dung to the forest, and your lordship, the stretch of that field, from that field to the jungle, was for 5 kilometers. Your lordship, it is highly improbable that not a single person was a witness to this act. Yet, your lordship, the prosecution has failed to bring on record any person who have been an eyewitness in this case. Your lordship, in the FIR, it has also been alleged that after being dragged for 5 kilometers to the jungle, the informant was raped for 3 consecutive days by the appellant and the co-accused person. Yet, your lordship, in the medical examination, it has come that the informant had close to no external injuries and no internal injuries. Regarding the evidence on sexual intercourse, it has been stated that it is present, but the same is old. Your lordship, there are grave inconsistencies in the version that has been given in the FIR and the deposition of the victim herself. Your lordship, in the FIR, it has been stated that on the third day of having been taken by the appellant forcefully, she was released by the appellant himself. However, your lordship, in her deposition, she has stated that she was taken to the house of the appellant's uncles, to the house of the appellant's uncle, and that is where she fled away on her own, and she came to her parents' house. Your lordship, there is a delay of 3 days in filing of the FIR, and no explanation has been given for the same. Your lordship, if you look in the depositions of the parents, that is PW2 and PW3, they have stated that even though their daughter was missing for 3 days, they did not bother to report this to the police. Your lordship, this suggests that her parents were quite sure that the daughter had eloped on her own will, and had not been taken forcefully by anyone. Your lordship, the appellant has been languishing in custody since 1st of June 2017. First of June, your lordship, 2017.
Sentence is for 10 years.
Yes, your lordship, 10 years and 7 years concurrently.
You have not completed half the sentence.
Yes, your lordship, is in 4 months and 4 months, 9 months, 5 days, your lordship.
4 years, 9 months.
Yes, 9 months, your lordship. 4 years, 9 months.
When you will complete half the sentence?
Your lordship, there's nothing has come on the medical examination also, your lordship.
When will you complete half the sentence?
Your lordship, in June, I'll be completing half the sentence.
Let this case in the last week of June, as the appellant has not completed half the sentence.
Obliged.
Serial number 17, criminal appeal DB 1090 of 18. Mr.
I am
Anup
appearing on behalf of the appellant in this case, Lordship. The appellant has been convicted under section 376 of IPC for 10 years, Lordship. This is the second time for the suspension of sentence, Lordship. And this is a matter of love affair and consensual relationship, which is apparent from the prosecution witness, Lordship. The Lordship may kindly permit I read the relevant portion of the PW2, Lordship, who is the victim cum informant. PW2 is the informant cum victim, Lordship. Para 7. हीरा बावरी मेरे मोहल्ले में रहता है. हीरा बावरी का मेरे घर पर इस घटना के पहले से भी आना जाना होता है. पारा 8. इस घटना के पूर्व भी हीरा बावरी ने मेरे साथ जबरदस्ती शारीरिक संबंध मेरे घर पर बनाया था. मेरे साथ हीरा बावरी ने हर बार जबरदस्ती शारीरिक संबंध मेरे घर पर ही बनाया था, लेकिन मैंने इसके पूर्व कभी भी अपने घर वालों से हीरा बावरी की शिकायत नहीं किया था. घटना के समय में घर में अकेली थी. हीरा बावरी मेरे घर में आया, करीब आधे घंटे तक मेरे घर में रहा. पारा 9. मेरे घर के आसपास सटा हुआ बहुत सा घर है. मेरे हल्ला करने पर अगल बगल के लोग आए थे, जिनका नाम मैं नहीं बता सकती हूँ. हीरा बावरी मेरे घर में जब घुसा तो मेरे द्वारा हल्ला किए जाने पर मेरी माँ और मेरा भाई आया था. पारा 10 लॉर्डशिप. हीरा बावरी को पकड़ने का प्रयास मेरे भाई ने किया था, लेकिन वह भाग गया. घटनास्थल पर बगल के लोगों के द्वारा हीरा बावरी को लॉर्डशिप कस्टडी सिंस 3 years and 11 months, लॉर्डशिप. Lordship, PW3 is the mother of the victim, Lordship. She says in para 5 that मैं हीरा बावरी को अपने घर से भागते हुए देखा था. मैंने भी हल्ला किया था. मोहल्ले वाले हीरा बावरी का पीछा नहीं किए थे. इस घटना के बारे में मेरी बस बेटी ने बताया। पारा 7 लॉर्डशिप, इस घटना के बारे में मोहल्ला में बैठक हुआ था जिसमें हीरा बावरी भी उपस्थित हुआ था, लेकिन वह बात नहीं माना।
You were on bail during trial?
Yes, Lordship. I was there in the bail, Lordship.
You were on bail during trial?
Yes, Lordship.
You heard the counsel for the appellant and heard the counsel. Which for the state?
I am for the state, my lord.
I am for the informant, my lord.
Yes, what do you have to say?
My lord, the 376 has been established from the evidence of the witnesses. And my lord, may kindly see the even in the judgment, my lord, this fact has come.
What is the age of the girl?
Age of the girl is, my lord, more than 19 years as per the medical.
So more than 19 years. There was some relationship since before.
That has not come, in fact, my lord. That has not come. The court has, the trial court has discussed this fact, my lord.
The evidence the girl has said, that the sexual intercourse had taken place earlier also, but you have not complained. Is it not?
It is come, my lord. He was, my lord, and due to the fear, she has, my lord.
Though the word rape has been used, but still, if the same thing has happened few months back and you have kept quiet and you have not lodged, and when the mother and the brother come,
ये कहते हैं कि इस घटना के पूर्व भी हीरा बावरी मेरे साथ जबरदस्ती शादी संबंध मेरे घर पर बनाया था. He has not consented, not stated that consented for.
Consented. What prevented you from lodging the case on earlier occasion? We heard the counsel for the appellant and heard the counsel for the state and the counsel appearing on behalf of the victim. Full stop. In this, by filing this IA, the appellant prays to release him on bail after suspending the sentence as he has been convicted for committing an offence punishable under section 6. Next, further, the counsel for the appellant submits that the appellant was on bail during trial. He submits that now he is in custody
from during the trial for 4 months, Lordship, and after conviction from 7/9/2018.
And he is in custody from 7/9/2018. That is the day of the judgment. He submits that he was in custody for how many months?
4 months.
During trial. Full stop. Considering the fact that the appellant was on bail during trial, we are inclined to release this appellant on bail.
Much obliged, Lord.
Subject to the condition once in 4 months before.
Obliged, Lord.
Yes.
Possible.
Possible, no?
There are two possible. Pass over matters. Serial number 1, Criminal Appeal DB 571 of 17. Mr.
Yes. Where is Mr. Majumdar? Who is appearing? When the case was called out initially, adjournment was sought for.
May appear in this case. Mr. Majdari is still on leg in court number 5.
So we'll wait for it. We'll wait for it. We'll wait for it. And this case was adjourned on the request of the learned counsel. On the second petition also, when the case is called for, no one prayer has been made to adjourn this case. So this case is adjourned.
The state is present, Your Lordship.
Yes, prayer has been made to adjourn this case on behalf of the appellant.
God bless you.
Serial number 4, Criminal Appeal DB 91017.
What's the same prayer that Mr. Mazari is the unbig.
Same order. Same order.